lot of people know that there's a room here too.
Yeah.
So okay.
No.
Anyway, so welcome again on this panel on public law history. We have three interesting lectures today, and the first to kick off is Gergely Deli, who is an advisor at the Constitutional Court in Hungary and associate professor at the University of Gergely. He studied in Budapest. He has also a degree in English law from Cambridge University and an LLM degree from New York University. And his research is on Roman law and comparative law. And today he will talk about human dignity in transition. You have the floor.
Thank you, Sebastiaan. I think I should start. Since 2012, we have a new constitution in Hungary. With this new basic law also came a modified understanding of human dignity. In the presentation, I explain the role of the historical narratives behind this change. We normally assume that historical narratives may support a given decision. I argue, however, that historical narratives also do a much dirtier job. First, they might hinder human dignity from its fulfillment. And second, they make law a contradictory system. To demonstrate this statement, I compare two decisions of the Hungarian Constitutional Court. The subject of both decisions has been the same rule of our criminal code. It is therefore remarkable that the two decisions reached at totally different conclusions. The norm in question is the following. Any person who distributes, uses before great publicity, exhibits in public a swastika, the SS sign, an arrow cross, second hammer, a five-pointed red star, or any symbol depicting the above is guilty of misdemeanor, punishable with a fine, if such act does not result in a criminal act of greater activity. To give you a better understanding, I list the most important historical events chronologically. In 1990, Hungary experienced a democratic transition from socialism. Although we beware the old socialist constitution from 1949, it has been substantially modified according to the Western democratic standards, and the full catalogue of human rights has been added. In 1990, the first re-election has been held. That was the proper time to face all the terrible crimes of the Nazi and socialist periods. This process soon became a very sensitive political issue, as both the offenders and the victims lived among us. In 1993, the Parliament modified the criminal code and introduced the above-mentioned criminal offense. In the same year, petitions arrived at the Constitutional Court seeking the annulment of the new regulation. The petitioners argued that the provision violates their fundamental right to the freedom of expression. We had to wait 7 years for the decision of the Constitutional Court. In 2000, the judges finally rejected the petitions. As I already mentioned, in 2012, under the auspices of the second Orban government, the new basic law of Hungary took effect. Compared to the old constitution's formal legal guarantees and rather individualistic approach, the basic law in force has a substantive understanding of human dignity, and its general outlook is much more collectivistic. The document starts with the solemn-sounding chapter of the national avowal, followed by the so-called foundation. Here we find not only the classical fundamental values of constitutionality, such as the rule of law, the separation of powers, or popular sovereignty, but also the value judgments of certain historical events, such as, I quote, "We do not recognize the suspension of our historical constitution due to foreign occupations. We do not recognize the Communist Constitution of 1949, since it was the basis of a tyrannical rule. Therefore, we proclaim it to be invalid." Shortly after the new basic law has been promulgated, new petitions arrived challenging the constitutionality of the above-mentioned rule of the Criminal Code. In 2013, the Constitutional Court decided that the norm was unconstitutional and annulled it. The question comes naturally. How could we explain these diametrically different decisions after a period of just 13 years? To answer this question, let us see first how the concepts of human dignity differ in the old constitution and in the new basic law. The most important difference is that the old constitution, rightly to our mind, did not give a substantive definition of human dignity. I will call this concept the freedom-based conception of human dignity. The basic law suggests, in the contrary, that the substantive values of the national avowal and the foundation make part of the human dignity of the Hungarian people. This is what I call the value-based concept of human dignity. You might think that these two conceptions of human dignity are contradictory. It is not true, however. The merit of the freedom-based concept is that it makes the existence of any kind of human dignity possible. It is only a form which can be filled by any substantive content of human dignity. The value-based human dignity is, on the contrary, based on some well-defined, well-specified values, as we have seen in the case of the Hungarian Basic Law. In this way, it excludes any other different conception of human dignity. The two concepts are therefore not equal. They stay in a quantitative relation to each other. The freedom-based conception is more because it can handle a value-based alternative. The value-based approach, however, is in conflict with all different interpretations. According to these rather theoretical considerations, the first decision has been formally right because the freedom-based human dignity concept allowed the acceptance of a certain kind of historical narrative, the anti-tyrannical narrative, without the infringement of the Constitution itself. The second decision, however, should have followed the clear historical narrative of the Basic Law. At the very end, the second decision did not correspond neither with the value-based human dignity nor with the special historical narrative of the Basic Law. Now let us turn to the historical narratives behind the two decisions. The old constitution itself didn't tell too much of its own historical narrative. At the moment of the change of regimes in 1989-1990, it understood itself as a transitory legal vehicle toward parliamentary democracy and free market economy. The first decision under this constitution, however, accepted a historical narrative similar to the law which modified the criminal code and introduced the prohibition of the use of totalitarian symbols. In the preamble of this law in question, we find the following historical narratives. I quote again. In Europe and in Hungary, the extremist political theories of the 20th century created, through the forced grabbing and the exclusive possession of power, dictatorship that neglected human rights and led to the mass execution of Hungarian citizens. The use of the symbols of states, organizations, and movements that have adopted such extremist theories tears up aging wounds and is irreconcilable with the constitutional values of Hungary. The new Basic Law, as we have already seen, has a similar and very clear historical understanding. I quote again. We declare that no statutory limitation applies to the inhuman crimes committed against the Hungarian nation and its citizens under the National Socialist and Communist dictatorship. We date the restoration of the self-determination of our state, lost on the 19th day of March 1944. This was the day of the Nazi occupation of Hungary. From the second day of May 1990, when the first freely elected popular representation was formed. We shall consider this date to be the beginning of our country's new democracy and constitutional order. Surprisingly enough, the first decision has a historical narrative similar to that of the Basic Law and found the prohibition constitutional. On the contrary, the second decision, under the Basic Law, declared its unconstitutionality and annulled it according to the freedom-based conception of human dignity present only in the old Constitution. To understand better how this disorder emerged, let us examine the relation between human dignity and historical narratives in a more abstract manner. I hope you can follow this slide. The historical narratives and the human dignity have a very special relationship. First, they mutually define each other. Second, the relation is not free from a serious contradiction. The history determines human dignity in the way that the freedom-based concept of human dignity appeared at a certain point in the history. The appearance of this concept has not been a logical necessity. It's just only a historical fact. It is important to understand that it necessarily means the end of a development. From the standpoint of human dignity, the freedom-based human dignity, only deterioration or stagnation are thinkable. So that's what I like to demonstrate here, that at a given moment of history, we is linked a certain concept on human dignity, and there is a point in history where this freedom-based concept came in the picture, and theoretically only, it's the end of the development, because you cannot have a freer or much more complex, more liberal understanding of human dignity. That's the end when you say that human dignity is untouchable and free. There is no step forward. That's why in the future, in the practice, we don't know whether we can stick to this stagnation with this achieved level of protection of human dignity, or it goes downstairs. On the other way around, from the viewpoint of the freedom-based human dignity, the different historical narratives should be equal and neutral. On this basis, we cannot differentiate between people according to their own historical narratives. It is not only a logical consequence, but also suggested by the prohibition of certain forms of discrimination that are based on national, ethnic, or racial origin. It can be hardly disputed that the birth into a given community also means a placement into a given historical narrative which is totally independent from the person. It is important to note that among all forms of discrimination, only those which are related to a historical context cannot be changed. Political views, religion, but today even the color of the skin and the gender are changeable at wish. The nationality, here I mean nationality in ethnic sense, the ethnicity and the race last as long as the person lives. They are determined once forever at the moment of the birth in an irreducible historical moment in a given setting of historical narratives. The paradox between human dignity and historical narratives is exactly this. It is obvious that some kind of narratives constitute a part of any person's human dignity. Either he accepts them, or he is neutral to them, or he even refuses them. Consequently, it is not only and not the most important function of historical narratives to legitimate certain legislative or judicial acts. It is far more important that the mere existence of diverse historical narratives prevent human dignity from an absolute free development. In addition, the pure existence of historical narratives makes law contradictory. It is because the law should treat everybody's human dignity in an equal manner, and at the same time, the law should be acknowledged that human dignity depends on some given, objectively given historical narratives. The inevitable presence of historical narratives becomes a legal problem, not because historical narratives are as they are, only because they are. In the first case, a non-normative, anti-totalitarian historical narrative overwrote the freedom-based concept of human dignity of the Constitution then in force. the same anti-totalitarian historical narrative became legally binding due to the Basic Law. It has been put aside, however, by the freedom-based approach of human dignity, which was not legally valid anymore at the time when the second decision has been made. The reason was that a different narrative, a historical meta-narrative of the justices, has labeled the same anti-totalitarian historical narrative differently in the two cases. To sum up, the main function of historical narratives is not only to underpin a certain decision. It is only a potential, although we should admit, not harmless possibility. Maybe a more important characteristic of historical narratives in legal context that they necessarily hamper human dignity and that they endow law with a normally not desirable quality to make it contradictory. These are not only theoretical possibilities, but strongly influence the legal practice as well, as we have seen from the two cases of the Hungarian Constitutional Court. Thank you for your attention.